Dear colleagues, good morning. I'd like to inform you that in this meeting we have members of the International Public Council of International Councils, and these are their names, and members of the High Qualification Commission: Ludmila Volkova, Vitaly Patsiluk, Yaroslav Dukh, Roman Kodosyuk, Ruslan Melnik, Alexey Amelyan, Roman Sabotage, Ruslan Sidorovich, Serhiy Chumak, Helena Sevchuk. I, Andrei Pasechnik, I chair this meeting. We have the secretary of the meeting, Irina Lopushnak. We have the quorum and a special joint meeting of the High Qualification Commission of Judges of Ukraine and the Public Council of International Experts is taking place with a live broadcast. First of all, I'd like to thank once again our international experts that despite of the war risks, you're helping us. We appreciate that, and we really thank you. As we now have a direct broadcast, I think that many judges and candidate judges and would-be candidate judges are watching this meeting, or at least will watch it as it would be recorded. So I'd like to give the information about our members of the Public Council. So the chairman of the Public Council, Robert Heinberg-Heisen, at the moment is a lawyer from the Netherlands. In the past, he worked for the prosecutor's office. He worked with investigations of anti-corruption cases inter alia. He consulted proper UN bodies, the international banks. He specializes in investigating anti-corruption related cases and studying issues related to money laundering. He's a member of the Committee on the Selection of Members of the High Qualification Commission, so he has the experience of working with Ukrainian candidates, analyzing their files and their materials. I would also like to know that at the Public Council we'll have Gabriela Yutkaitė-Granskienė, Judge of the Supreme Court of Lithuania, Head of the Criminal Panel Chamber of the Court, Doctor of Law, and Professor of Vilnius University of Law. Norman Aas, lawyer from Estonia. Between 2005 and 2014, he was the Prosecutor General of Estonia. Later, he became member of the institutions that dealt with selecting prosecutors and judges, including judges of the Supreme Court, so he has a very relevant experience for us. Jessica Lott Thompson. She worked as a federal criminal prosecutor in Canada. Later, she was the Minister of Justice of Canada between 2017 and 2019. He was a member of the Consultative Council on Judges in Yukon and participated in selection of judges in Canada, including the judges to the highest levels. John J. O'Sullivan, retired judge in the United States of America. Before that, he worked at the Prosecutor's Office, investigated corruption-related cases. He participated in investigating clamorous cases related to corruption at the prosecutor's offices and the judicial authorities. At the moment, he's retired, as I said. He pays a lot of attention to teaching at various universities, including at the Federal FBI Academy. I would also like to know that a member of the Public Council of International Experts is Marika K. Butler, who is not participating with us here today, but she's a great friend of Ukraine who, since 2022, has provided a lot of assistance to Ukraine, to its law enforcement authorities on issues related to sanctions, to looking for Russian assets, but unfortunately, because of some objective reasons, she cannot participate in this meeting today. I hope that she will participate in the future meetings. She will join us So I'd like to say that the members of the Public Council of International Experts has experience in both investigating corruption-related cases, so they understand what challenges the future judges of the High Anti-Corruption Court can face. They have the experience of selecting people to high-ranking positions in public services in their countries. They have very relevant experience of selecting judges, including judges to the highest positions. I believe that this experience will help us to work as productively as possible to select the best candidates with good professional qualities and integrity. And I would also like to thank our candidates, both the ones who are present here today or tomorrow, as well as the ones who have submitted their documents but unfortunately could not overcome a certain barrier in our competitive procedure. On behalf of the Commission, I'd like to thank you for your boldness. It's not a simple step, it's a serious responsibility to participate in such a competition so as to take positions in the High Anti-Corruption Court. And I would like to call upon of you you have demonstrated high level of knowledge, and I would like to ask you not to give up, to get better prepared and participate in the future procedures that the Commission would announce. I'd like to thank our international partners for their permanent support that they're giving us, to the Commission, to the Public Council of International Experts. And now I'd like to give the floor to the Chairman of the Public Council of International Experts, Robert Brookhiser. Please, the floor is yours.
Thank you, Mr. Chairman, and members of the High Qualification Commission of Judges. For us, it is an honor to be here to, together with you, select judges for the High Anti-Corruption Court, which we all know is important for the future of Ukraine. You all will know that we had a bumpy week here behind us because suddenly our support of our donors was falling away. And from us, we have to reach and to thank especially the EU anti-corruption initiative that they were able and willing to step in and make sure that we had sufficient support to do our work. We also have to be very thankful to our Ukrainian assistants because whatever happened, they continued helping us and supporting us in every way they deemed fit. And we are really quite proud that they were willing to do so. We also have to thank, I have to thank my fellow members because they are willing to come to Ukraine even though the support had completely gone. And I can tell you that quite strange and unexpected things happen. And we also have to thank the government of Denmark because they stepped in by themselves to make sure that we can do our work. And we also have to thank the government of the United Kingdom because they also make it possible that we do our work. So we are now here, we are prepared, we are happy to go forward. I wish the candidates luck. I think that to do this is quite a step. It is not easy to have an interview with so many people in this quite magnificent room. And I wish them luck and all the best. And well, let's go forward. Thank you, Mr. Chairman. I give the floor back to you.
Please bring your microphones much closer to you because we can hardly hear you. So the first position is about whether the candidates meet the criteria and the law on the Anti-Corruption Court of Ukraine. The list of the candidates: Yurii Bodnaruk, Oleg Mostachov. Sorry, the microphone seems to be off. And Mikhailo Odaruk. Will the members of the Commission and members of the PCIE any comments as regards the number of issues we are to discuss? No proposals. We are to adopt the list of questions we're going to ask the candidates. Vote, please. Thank you. Yes, thank you. Unanimous. We have adopted the list of questions, and I suggest to do it. We have the following agenda here. In particular, speech of a member of the PCIe up to 10 minutes, response up to 10 minutes, questions from the PCIe up to 30 minutes, questions from the Commission, 40 minutes. Any member can ask any question to the candidate. The President of the Commission and the President of the National Commission of Judges are to control the time frame. Are we adopting this agenda? Let's vote, please. Thank you. It is unanimous. We've adopted the agenda. I will ask the Secretary of the Commission to inform us about whether the candidates are present at the meeting.
The
candidates who have been invited have come to this meeting, namely Yurii Bodnaruk, Oleg Kimstachov, Tatiana Litvenko. The candidate Mikhailo Odaryuk has sent his request to participate in the video conference mode. The candidate can participate in this meeting via a video conference, via Zoom platform. Thank you. Please invite the candidate judge to the High Anti-Corruption Court of Ukraine, Yurii Volodymyrovich Bodnaruk. Good morning. When you answer, please push the button, then your microphone will be on. The question we are discussing is whether Yurii Bodnaruk meets the criteria in Part 4 of Article 8 of the Law of Ukraine on the Anti-Corruption Court. We have here the members of the Public Council of International Experts, as well as members of the High Qualification Commission of Ukraine. These are the names of the members of both commissions. You have the right, first of all, to suggest that some of the members of the Commission be taken off. You can make your comments and respond to the questions, or you can appeal the decisions. In this joint meeting, we're not discussing any new material submitted by the candidate. If they could submit them before, and if the candidates have not submitted them to the Commission, with these circumstances that can affect significantly the decision of the Commission on the initiative of the commissions with a majority of the votes of the PCIe and HQCJ. Some additional materials can be added if at least 3 members of the PCIe have supported that. I'm giving the floor now to Oleg Kolish. Good morning, dear colleagues. Good morning, dear candidates. I have to announce this information because I'm the acting judge of the High Anti-Corruption Court and also member of the Commission. At the moment, I have to inform you that the circumstances to be found in Article 100 of the law on judges and the status of judges are not there. At the same time, this information is to be disclosed. So if the candidate has any grounds to recuse me, then he should know this information. Thank you.
Would you like to file any recusals for the members of the Commission or any other motions? I don't have any motions or recusals at this point. Thank you. Are your rights and obligations clear to you? Yes, they are clear. Thank you. We have earlier approved the rules of procedure. I will announce the rules of procedure and the time limit for the hearing, the report of the PIC, up to 10-minute explanations, up to 10 minutes questions and answers of the PIC, 10 minutes questions of the Commission members, up to 40 minutes. The rapporteur is Sabotage Roman Bogdanovich. The floor is over to you. Thank you. Good day. So, brief background about the candidate. In 2003, he graduated from the National Legal Academy, have received a higher education, was qualified. In 2004, he graduated with a higher legal education. He has a candidate of legal science, and he's associate professor. In 2022, he participated in the competition for the members of the High Qualification Commission of Judges and was recommended by the Competitive Selection Commission for the appointment. The decision of the HKC was to turn him down as a member of the Commission on the 20th of March 2024. He applied for the composition of a judge in the High Anti-Corruption Court of Ukraine, scored 150 points. Cognitive test was 51.3. A practical assignment was 118 points. The decision of the committee of 2025 admitted him to the second round of the round, and the interview on the 27th of January, the PIC initiated a special joint hearing. Yurii Bodnaruk works as the assistant judge in the Secretariat of the High Anti-Corruption Court of Ukraine. My briefing is over. The floor is given to Robert Hein-Prukasa, the chairman of the Public Council of International Experts.
Thank you very much, Rapporteur of the HQCJ. I would propose to pass the floor to my dear colleague John O'Sullivan, who is the rapporteur on our side on this candidate.
Thank you, Robert. First, let me say that it's a privilege to have been appointed by the HQCJ to participate in this procedure and to assist them in qualifying candidates for appointment to the High Anti-Corruption Court. Is it okay to call you Yurii? Yes? Okay. First, I'd like to introduce my colleagues to you. All the way at the end here is Norman. Norman is an attorney from Estonia. And sitting next to him is Gabrielle, who's a Supreme Court judge from Lithuania. And then we have Robert, who is our chairperson and is a attorney in the Netherlands. And finally, Jessica, who's sitting next to me, who is an attorney from Canada. My name is John O'Sullivan. You can call me John if you like, or you can call me anything you want, but John is okay. I'm a retired judge from the United States. And as I said, I'm very happy to be here. I want to congratulate you on making it this far in this competition, because it's a very competitive process. And you're one of the lucky few who are here today and tomorrow to participate in interviews. So good luck to you. What I'd like to hear from you initially is, well, there's a few things I want to address with you. One is your motivation, why you want to be a judge on the High Anti-Corruption Court. The second is I want to talk to you about some of your finances, your purchase of an apartment in Odessa, money that you received from your father, a considerable amount of money, and also your purchase of several cars over the years. So to start, if you would like to introduce yourself and tell us why do you want to be a member of the High Anti-Corruption Court?
Firstly, I would like to thank the rapporteur for the report on my background. I would like to say that I'm applying as an academic, as a person who has the academic background. My academic interests lie in the area of financial, tax law, and legislation, and I have relevant experience of practicing law as a corporate attorney and as a defense attorney, but the most relevant experience that I have, speaking of this competition, a competition for the position of the judge of the High Anti-Corruption Court, it would be the most recent experience over 5 years of working as the assistant judge in the appellate chamber of The Hague, where I dedicated a lot of time performing the role of the assistant judge, writing draft decisions as ordered by the judge, and developing interesting legal positions, again, as requested by the judge, as is instructed by the judge, and under the leadership of the judge, who I supported. It is Mikhailenko Dmytro Grigorovich, and quite a number of interesting and useful legal opinions were passed to form the case law of the anti-corruption justice, and I am proud to have been involved in these processes. As for my motives, I am very sorry I have to interrupt you, Yurii Volodymyrovich. There's an air raid warning in the city of Kyiv. So I suggest we make a recess in the broadcast of the meeting and we transition to the bomb shelter for the duration of the air raid. In 3, 2, 1. Dear colleagues, shall we continue the hearing? Over to you.
Thank you. So, Yuri, I apologize for the interruption, but we'll blame that on the Russians. And I'll ask you to continue telling us why you want to be a judge of the High Anti-Corruption Court.
Thank you for the opportunity to continue. I last said that as the assistant judge of the appellate chamber of Hague, I was involved in the discussions in drafting the court judgments that are useful, interesting, and beneficial, and they pertain not only to the application of the criminal procedure, but it's commonly known that currently the competence, the remit of the Hague is broadened, and these are high-profile cases such as civil forfeiture or finding the assets unjustified, as well as sanctioned cases, and we also reviewed on appeal some key interesting cases, and we provided interesting findings. So I feel that I'm capable of performing the duties of the judge. Earlier, as the rapporteur had mentioned, I applied for the position of the appellate judge back in 2019, and the competition didn't happen because the High Qualification Commission was disbanded. So this must be all, unless there are some clarifying questions or some additional information is needed. I have completed my answer.
You've worked with the Hague for over 5 years, as I understand it. What do you see as the strengths and weaknesses of the High Anti-Corruption Court?
That is an interesting question. The strength, as you say, or rather the advantage of the Hague is primarily about shaping the case law that has evolved over the 5 years of its operation. The thing is why the Hague was put together was that the corruption cases earlier made it to the indictment for obvious reasons, and something had to change. Therefore, the High Anti-Corruption Court was established, and the opportunity to change the key instrument was about changing the case law, because the Criminal Procedure Code was enacted back earlier, but there was no established case law of applying the criminal procedure. So the application was diverse depending on the courts, depending on the judge's opinions, but it never made it to convictions. And the key vector and the key direction of the 5 years was that the application of the procedural law primarily prevailed the consideration on the merits. Usually, it's about admissibility or inadmissibility of evidence, some formal violations, and the assessment of these violations by the court. So currently, there is a concept, I would say, and a big contribution was made by Mikhailenko Dmytro, his honor that I work for. And according to this concept, which has been upheld by the Supreme Court and implemented by the Supreme Court in parallel, that a petty formal violation should not lead to the consequences of rendering all the evidence inadmissible and the defendant have to be acquitted. We need to make an assessment of the gravity of violations. Two questions: whether the violations are significant of human rights and freedoms, that there are so two key areas, or whether these violations can shed doubt on the admissibility of evidence. We have the practice on the two matters. As for strength or advantage of the hack, it is about the judges who were selected during the first competition. They are intelligent, they are diligent, conscientious, persistent. I, as the judicial assistant who is involved in the review, we read the verdicts, and the quality of the verdicts is far superior to the court judgments rendered by other courts. And the key reason is the different degree of workload, caseload. The general local courts and the general appellate courts have a significant caseload, and they don't have the time for quality preparation of the decision.
If I may interrupt, I would ask you to answer concisely because we have many questions for you. And I would suggest that any answer you give is within 3 minutes. So we have sufficient time left for other answers.
Yes,
Is that okay? Thank you.
And the second reason is the staffing of the judges, but as well as the court staff. We have highly qualified judge assistant and court officials. The disadvantage that is criticized by the public and perhaps others is that some cases take a long time to adjudicate, and this selection, this competition is intended to hire new judges to even the caseload and speed up the case review. Concurrently, some changes were introduced to the Criminal Procedure Code in order to steer away from the panel of judges sitting in all the cases, and now some cases will be considered by a single judge, and I hope I've answered your question.
Having been a judge, how vital assistants to judges are to keep the system moving. I did notice, do you speak English? Because I noticed you weren't using the translator up until now.
I don't speak English, but no, перепрошую, я розумію більшість
I
того,
do
що ви
understand
кажете,
most of what you're saying, but I'm just playing safe and listening to the interpretation.
Okay, that's a good idea. So I want to move on to the next issue that I'd like to discuss with you, which is the apartment you purchased in Odessa in August of, well, it was completed in August of 2020, but the payment was made, the payment for the apartment or the cooperative was made in February and June of 2016. Is that correct?
Right. As for the purchase of the apartment, I did receive your written request and I tried to give a full explanation. The matter was that in my declaration for 20 or 21, the right of ownership in the apartment is registered that I did buy in Odessa, but in fact I bought it back in 2016. This matter was discussed during my participation in the previous competition, so I bought it in 2016 by paying 2 installments. The first was about 400,000 hryvnia and the other was 700,000 hryvnia. In the second and 12 months. So I've paid the down payment in 2016, but from 2016 to 2020, I did not document my property title to this real estate. And when I did, I reflected it. Before reflecting it as an apartment, I declared this real estate title as an incomplete construction. And after the state registration, when I became the official owner, I listed it in a different section, stating the acquisition value, which is fully consistent with the payment record that I sent to the Competition Commission address and the public account.
When you purchased the apartment, it actually was not considered residential. Is that correct?
Yes. First of all, it was not even an immovable property object because I purchased it in a building that was only being built at that time. The construction of it was not yet completed, so it was not a residential property. It's true. When I bought it,
It was actually a upper floor, correct? That was not to be used for residential originally?
Дивіться, це
look,
останній поверх.
that's the last floor, the upper floor. And according to the documents, it is considered to be a technical floor. In other words, besides the space that can basically be used for living, it also has some communication lines, a special room to service the elevator. So according to the documents, it was really the so-called technical floor. And it was called artistic shop. And that's what in fact declared, as an artistic shop.
You were, through the use of a lawyer, able to have that declaration changed to allow it to be used as a residence?
Yes, exactly so. Well, I didn't do that personally because at that time I already was working in Kyiv, and I turned to a lawyer I knew well, who were experts in this area. The thing is that the certified experts, they studied these conditions, they checked that they were in line with the requirements for residential premises, that it had all the necessary communications, all the equipment, that one could reside there. They made their conclusion and they registered it as a residential premise.
Do you think there's any ethical issue in converting that to a residence when it was originally not to be used for residence?
Frankly, that's my personal position, and of course I can be biased here. I don't think that there are any ethical reservations here, because that's quite a widespread practice. I did not even have to register it as a residential facility. It could continue staying a non-residential area. But in Ukraine, that's quite a popular and a widespread practice where people live in such premises. The only thing, the other reservation there is you could not register yourself as living there, but if the conditions are right, you can live there.
So let's go back to the purchase of the apartment. I have here your responses to the second round of questions where you were very specific about how you accumulated the funds to purchase the apartment. I'd like to go through it with you. So, and tell me if I'm correct. In February of 2016, you made a payment of 409,000. Yes. She's going to say the word for me because I can't pronounce it. And then you made an additional payment later that year of 761,300. Is that correct?
Так, так.
And at the time, at the end of 2015, in US dollars, you had approximately 22,300 equivalent US dollars available as savings. Is that correct?
Так.
And you took, for the first payment, you took $15,000 and used that for the initial payment. And then you owed another approximately 29,000 US dollars to complete the purchase, correct?
Yes.
And you only had $7,300 left in your savings because you originally had 22,300. You had already given them 15,000. So that left you $7,300 approximately in savings, correct?
Так, так.
Yes. Right.
And that wasn't enough to pay the remaining approximately $29,000, was it?
Так.
Yes.
So you, at that time, you received approximately 30,000 US dollars from your parents.
In 2016, after I made the first payment,
Yes.
they lived in the city of Mykolaiv. I came to them. We discussed that issue even before I signed the documents, the investment papers. I took that money from them with their permission, and I made the second installment in the late 2016.
And where did they get the approximately 30,000 US dollars from? Where did your parents get it from?
Це були початково мої гроші.
Well, originally that was my money that I had given them before, earlier, maybe in 2015 or maybe even earlier than that.
Мали можливість
So they
розпоряджатися.
could manage the money. We had some plans at that time that they would improve their living conditions and they would perhaps move and exchange their apartment for a better one, including in Odessa. They could also manage the money for any current needs. That's why in my declaration of 2015, where you have to declare the assets that you have at on the very last day of the year. And I believed that I didn't have the legal grounds to put in the declaration the money that I had given them, because I had in fact presented this money to them. And in 2016, when I had that need and we discussed it with my parents to purchase that apartment in a new residential project in Odessa, we discussed it with them and I took the money. And because I was the one who had to declare it, and I declared that operation in 2016. However, I was not the person to make that public declaration because I had never been a civil servant at that time. And means that there is only one declaration I had to submit, that of an assistant judge related to my work. All the other declarations were declarations made by candidates to certain positions. That's a slightly different type of declarations. The members of the HQCJ know the specificity of them. They work with that. And incidentally, I also want to draw your attention to the fact that I tried to diligently, and sometimes even I provided even too much information in those candidate declarations. For example, there is a section on legal deeds, and I would fill it in even although I did not have to do that, didn't have to provide that additional information, but I did.
But even though you provided that information, you didn't see fit to put on that 2015 declaration that $30,000 of your money was with your parents.
Yes, because I believed that I didn't have the legal grounds to declare it as my own assets.
Okay. So before you purchased this apartment, where did you live from approximately 2004, let's say up till 2016? And then from 2016 to 2020 when the apartment was completed?
I lived originally at a student hostel where not only students but some teachers, trainers lived there. It was starting in 1999 and until probably 2008. Then for several years.
How much did you pay for the student living, the hostel, as you called it?
It was almost for free because the pay was so low that one could also say it was free. I think it was like 25 hryvnias a month or something like that. It didn't even cover the municipal fees. It's not even believed to be, it's not even a lease. It's what a university gives you, in fact, and they pay for. So it was kind of a zero.
And so after 2008, where did you live? From 2008 to 2016?
Then for several years, I rented an apartment together with a friend. We paid half 50-50 for it. And then my parents acquired an apartment in Odessa, and on all of the declarations, I in fact put it down as my residence address of this other apartment. And there I lived, I think, between 2010 or 11 until the apartment that I had purchased was finally built.
And so from 2008 to 2011, how much were you paying rent when you were living with a roommate?
Frankly, I cannot even remember that because, well, nobody had ever asked me those questions, not even you, and I don't think I have any documents.
Would you please talk into the microphone? Because the translator cannot hear you. Yes, it's important that the microphone is close to your mouth.
Right, thank you. In 2008, that was 17 years ago, I don't even have those papers. You know, I could not foresee that I would ever participate in such a competition, and I would have to, no, unfortunately, I don't have those papers. I cannot even tell you. But it was just a usual apartment, not any luxurious apartment, a usual one, a standard one in an old house where we rented it and paid 50-50.
In our second round of questions, we inquired with you how you had sufficient funds to purchase this apartment in 2016. And you provided us with some computations. You indicated that in US dollars, over the 12-year period prior to the purchase of the apartment, you had earned approximately $84,172 in US dollars. Do you recall saying that in your response to our question?
Yes. Yes, I do remember. It was for the period between 2004 until the end of 2016, until I completely paid for the apartment. The amount of my income, which you can find in your calculations, and I converted this money into US dollars. Is your microphone on, sir? Is your microphone on?
Sorry. I just just want to go through your computation with you to, so the members of the commission and the council can understand. You then took that $84,000 and you said, well, taxes were approximately 15% of that. And you indicated that you had available to you approximately $72,000 during that time period. Do you recall indicating that in your answer?
Так, звичайно. Так, так.
Yes, certainly I do.
Так, пам'ятаю.
And then you subtracted from that $72,000 the $30,000 that you had given to your parents over that time period. You recall that?
Так.
Yes, I do.
And you also subtracted the money that you had left in savings prior to making a down payment on the apartment. That was $22,300. Do you recall that?
Звичайно, пам'ятаю.
I certainly do.
And that left you with approximately $19,700 US for that 12-year period, correct?
Так, ну я надавав два варіанти
Well,
розрахунку.
yes, I gave you two types of calculations, or two options rather. The first one was that from the amount of the pure income, I subtracted the cost of the apartment, and roughly I calculated how much money I had left for my everyday needs. And the other option, and I gave you two variants, and the other one was exactly what you are saying now, with account of the declaration of the income that I submitted in 2015.
By the way, in July of 2015, you purchased a vehicle, correct?
Не зовсім правильно.
Not exactly so.
Це питання мені ставили.
It's a question I have been asked at the High Council of Justice during the previous competition. There is a public recording of such an interview, and I answered that question by saying that, in fact, the vehicle was purchased roughly in 2012 on the basis of the notary's affidavit, and I cannot say exactly how much it cost. In 2015, I finally registered it as my own property, and as I didn't have a correct figure in order to meet the requirements of a declaration, which requires that the price of it should be declared. There was two possibilities, either how much it really cost or what its current price was. I looked at the website where automobiles were sold. I looked at the rough price of it, and I declared it. It doesn't mean that I really paid that money, and I didn't pay for it in 2015 because I had purchased it back in 2012. That's why in 2015 I didn't incur those costs. Incidentally, in my written explanations, I wrote about that, and I also wrote that I didn't buy that vehicle with my own money. Before that, I used to have another vehicle. I sold it. I added about $2,000, and I bought another automobile that I would then use. And to confirm that information, I also gave you a screenshot from my personal office at that website where vehicles are sold, where one can see that I had another car and at which cost I had purchased it and how much I paid for the other car that eventually sold as well.
On your 2015 declaration, you indicated, where it asked you for the cost at the date of acquisition, that you had paid 110,000 per hryvnia. Is that correct?
Ні, не зовсім.
No, not exactly so. Once again, let me repeat it. While filling in the declaration. Well, it was not the money that I spent in 2015. It was the cost of the automobile at its current price. And I decided what its current price was by looking at the website where automobiles were sold.
Okay, so presumably if you bought it 3 years earlier, it would have been worth more when you purchased it in approximately 2012, you've indicated.
Дивіться, я не можу, ну, в гривні
Look,
там, я не можу сказати.
Well, I cannot say whether in the hryvnias or in dollars because the exchange rate had changed, but I do remember that I sold the car that I had before. Well, it was called Deo Sense, and you would see the price that I received for it, and I added about $2,000 in the equivalent wallet, Ukrainian currency, but to be converted into US dollars. And that's how I purchased another car that was quite similar in terms of its year of production. It's just that it was a higher level car.
Okay, so in your answer to our question, you had indicated that you had approximately $19,700 to live on during the 12-year period before you purchased the apartment. You'd now tell us that you also purchased a car for approximately $2,000. So that would actually, you would have to deduct that from the amount of money that you had available. That would mean you had $17,700 available to live on for that 12-year period. And in your calculation, you then divided that by 12 years. And if you take the 17,700, to get my calculator out here, and you divide it by 12, that means you have $1,475 per year available. You divide that by 12 months, because there's 12 months in a year. That means you have $123 available a month. And the average month has 30 days. You divide that by 30, and that gives you $4.10 a day to live on. Do you believe or want us to believe that $4.10 a day is sufficient for a grown man to live on during the years 2004 to 2016?
Дивіться, ви правильно кажете щодо калькуляції.
You're saying it correctly in terms of the calculation. In terms for the calculations to be correct, we had to subtract that money to purchase a new car. But in my response to your question, I also indicated that all that income that we took into account, all those revenues, they only consisted of the salary that one can see in the tax register. And of course, it could not include the amount of material assistance that I received from my parents for my everyday needs, like food or whatever else, because according to the laws of Ukraine, this amount should not be declared, because this money assistance is coming from the family members. If parents are giving something to their children, or if children give any money to their parents, this is not to be declared in tax declarations. It may be declared in the property declarations, but therefore, it's true that one can subtract those $2,000, but one should take into account the other revenues that do not feature in the tax register. And it's hard even to calculate them over those 12 years, how much my parents had given me to help me, because of course that was what really happened. And I said that.
I did say so in my written answers that I have provided to yourself.
Well, actually, during that period, you were giving your parents money. You gave them $30,000 during that period. Is that correct?
Так, дивіться, я маю на увазі, так, ви все правильно розумієте,
Right.
що
Your understanding
я
is
їм
perfectly
вже
right.
надав свої
I
заощадження. Це
did
було
give my
близько
savings to
мого
them,
декларування.
and that
14,
was
можливо,
in
навіть
around
15 рік.
2014 or 15 when I filed the
Тобто,
declaration,
до цього періоду
and prior
хлопці мені
to that
допомагали.
time they supported me.
Дивіться, я там зазначав, якщо подивитись
I did
за
say that if you look back at the years 2012-24, the income for the period in equivalent, they comprised the 30,000, so the period between 2012 and 14, and up to that, they would have supported and did support me.
So let's move on to another area. You've told us in your, I believe in your declarations and in your answer to our questions, that in 2019, you received 270,000 in Ukraine currency from your father. Is that correct?
Так, це відповідає дійсності.
Yes, this is correct.
And that's approximately at the time, 11,400 US dollars.
Ні, за моїми підрахунками, там, можливо, за яким курсом
It
рахувати,
depends
я
on the
вважав,
exchange rate, and I
близько 10 тисяч
thought
доларів.
this was about $10,000.
Курс, змінювався, там
The
з'являлися
exchange
плюси,
rate
підходи. Це
fluctuated.
приблизно
There
еквівалент
are
10 тисяч
currency
доларів.
exchange rates, but
Але
I
можна
felt it was
вважати
equivalent to
і гривню рахувати так.
$10,000, but we can stay within the hryvnia calculation.
Okay. I mean, we did a calculation as of October 2019. The exchange rate was 11,392, but it doesn't really matter, 10,000 or 11,000. You indicated that your money, that your father got the money from the sale of an apartment that he owned in, correct, my pronunciation is probably going to be wrong, but Pervomesk.
This is
And
correct.
he sold an apartment there on October 18, 2019. Is that correct?
Чи 19-го року. Ну, я вам надсилав копію, скріншот.
19. I did send you the screenshot of the agreement. I believe this was the end of 2019.
Yes, yeah. And the apartment did not sell for 270,000 Ukraine. It only sold for 211,000. Is that correct?
Так, зазначена сума договору
Yes,
211
the
тисяч.
stated price in the agreement is
Це означає, що
211,000,
майже всі
meaning
кошти, які я
that
отримав,
almost all the
я отримав від
proceeds
продажу.
that I
Ну,
received,
хочу
I
зазначити,
received from the
трикімнатної
sale of a
квартири, нехай вона там
three-roomed,
вже була,
three
там, потребувала
roomed
ремонту, але
apartment.
це
It may have been
трикімнатна квартира.
somewhat run
І
down,
в
but it's a
місті, який
three-roomed
зазначений в договорі в
apartment,
Миколаївській області.
which is the second
В цій
biggest
квартирі ми
place in the
проживали, ну, весь
Mykolaiv
час,
region.
з
We lived
мого
in this
там
apartment
народження, скажімо так, з мого
from
дитинства.
my birth. I lived
Тільки
there
в
as a
тому році
child,
вдалося її продати.
and only that year
Фактично,
we
це
were
була наша
able to
квартира, вона
sell
там
it. This was
приватизована
our
була.
home. It
Просто
was
батько був
privatized.
зазначений як власник, і
My
він
father was
підписав цей
the
договір.
formal owner on the paper, so he signed the purchase and sale agreement.
Is your father still alive?
Так, дякувати Богу.
Yes, thanks God.
Okay, good. And so your father gave you the 211,000 that he got from the sale of the apartment, plus another 59,000, because the total you received was 270,000, correct?
Так, вірно.
Yes, this is correct.
Так, так.
Yes.
It's beyond the time.
We're running a bit out of time, Mr. Chairman. I guess that our rapporteur would appreciate to finish his questioning, or do you wish us to finish now and that you can go on with the questioning? Your rapporteur can go on with the questioning.
Якщо у вас залишили ще питання важливі, які ви
If you have
Е,
any
хотіли би
critical
поставити, то,
questions
будь ласка,
remaining that you
давайте
would like
закінчимо
to
з цим
pose
питанням.
to the candidates, would you please proceed with your questioning?
Okay, thank you, Mr. Chairman. If you would put the presentation on the screen so that Yuri can see it. So this is looking at your finances for 2019. Can you see that okay? It's a little hard, isn't it?
Не дуже, чесно кажучи.
Honestly,
So-
I can't quite see it. I will try to follow as you discuss it. If you need to, you can come closer to understand the question that being posed to you by the member of the public council. But let me remind you that you will still need to go to the microphone to provide your answer.
Okay, so this shows money that you had available to you in 2019 and money that you expended in 2019. And I'll go through first the money that you had available to you. When I finish that, if you want to make any comment about any of that, you're welcome to. The first is 123,200 in salary from a law firm. I'm sorry. From where? From the university, my mistake. The second is 14,103 salary that you received as a professor. The next one is 258,716 in salary you received from the court. Is that correct? Yeah. Then in that year, you also sold a Mini Cooper, for which you received 150,000. And of course, you had the gift from your father of 270,000, which totals 1,816,900 Ukraine currency available. And those figures we got from the tax authorities for the salary and your disclosure form for the Mini Cooper and the gift. So you agree that those numbers are correct?
Я перепрошую, я хочу передивитись свої записи, якщо можна кілька
If you would allow me to go
хвилин.
back to
Ну, в
my
цілому,
notes,
тому що
if I may
відповідаю
take a
зараз.
minute to look at my notes,
були
because
якісь
they are
там
mostly consistent. I did make the computations.
Yeah, just hold on. This is all information that came off of your disclosure form. Or your declaration.
Батька 2019 рік. Продажу автомобілю.
The gift from the father, the proceeds from the sale of the car.
Yes. And your salary. It's not a lot of information. Okay, so let's go to what you expended money on. So in the beginning of your declaration in 2018, you indicated that you had no savings. At the end of 2019, you indicate that you have 110,317 savings in the bank. You had 15,000 US dollars in savings, which is at the time was the equivalent of 355,000 Ukraine. You had repaid a loan to Mr. Pozar for $82,500. And you had purchased a Chevrolet Trax for $256,000. And in addition, you started renting an apartment in Kyiv towards the end of 2019. And you indicated in the response to your questions that you paid $17,600 in rent for the Kyiv apartment in 2019. You add all that up, it comes to 821,417 in Ukraine currency.
If you could please repeat the total.
Sure. And you can look at it on the board if you like. It's up there. 821,417. So you actually expended or saved more money than you had access to in 2019. Approximately 5,000 Ukraine currency in excess of the available money you had to you. And that doesn't include any expenditures you made on food, gasoline, restaurants, just maintaining your apartment, maintaining furniture for your apartment or anything else. How do you explain that you expended more money than you had available to you in 2019?
Дивіться, по-перше, хочу зазначити,
Look,
що
firstly, I wanted to say that as expenses, you included the value of the purchase of the Chevrolet Trax, 256,000. I did state the value, but the matter is that all these expenses were not incurred in 2019. This vehicle was purchased at an auction in the United States. I stated the initial price of a lot, and it's stated as the value about 91,000. In the summer, we bought the lot for a long time. It was shipped by sea to Odessa, and at the end of the year, it was late fall or so, because I was already working in the Kyiv court. So the car arrived damaged, and sometime later, we started repairing it. So some of the funds that I spent for the repairs were spent in 2019, but the bulk of the payment with the purchase of the spare part, the price of the works, and it's done on completion, and I made that in 2020. There is some inconsistency in terms of expenses for the purchase of the car Chevrolet Trax. I stated so in my written answers when the car arrived, and I provided the written explanations from Vadim to this effect. And the there's inconsistency about the price of the vehicle. It's 256. This is the value of the lot and the renovations which were completed in 2020. So you cannot put these expenses towards the year 2019. Moreover, I would like to state that there's a certain amount which is not eligible for declaration. It's below the threshold limit. So if I needed some money, I could loan them and settle my debt net year, and it was below the declaration threshold. I think it's up to 50 subsistence minimum where you don't have to put in your declaration. The government doesn't want to know these incomes or loans under the threshold amount. Thank you.
Very much. I'm completed with my inquiry, and thank you for the extra time, Mr. Chairman and the chairperson. Thank you.
Yes, and I give the floor back to the chairman of the HQCJ.
Дякую. Я хотів би передати слово доповідачу з числа членів
I
комісії.
would like to give the floor to the rapporteur for the HQCJ sabotage. Yurii, I have a few questions connected to the answers you provided to the Public Council of International Experts. If we may revert to your Odessa apartment, if you may clarify the floor that it is on, the 14th. Would you please say, in your opinion, why then the documents that hold the registration case on your apartment that you had also provided a declaration on the readiness for the launch of explanation of the object from 1 to 3rd quality? It says that the apartment block has 13 floors. I didn't notice that. I know the floor that I live on, and it's the 14th floor. I understand that.
I live on the 14th floor, and that means that the elevator comes up to the 13th floor, and then you have to walk one floor up. Can it be related to the fact that there are the so-called blue and red lines in the housing constructions? I'm not aware of that. That's where the number of floors is too high, which is contrary to the construction documents. It was an issue that was discussed already at the commission meeting, and I said during the interview that I had not known about that before I purchased the apartment, but later I learned, when I started getting interested in all those issues, not about the house where I lived, but about some other houses, and I learned that they had some multi-story houses, like a house would have 24 stories, of which 2 floors are considered as technical floors. I got interested in that, and I discussed it with the experts, and they explained to me that it is true when the documents are registered for a house to be built, they take into account the seismic maps, they do the expert assessment, and depending on where a house is located, depending on what kind of earthquake risks are there, and depending on the materials that have been used to build the house, a certain number of floors is allowed as residential floors. So some people would say we have 22 residential floors and 2 technical floors. In our house, it's 13 residential floors and 1 technical floor. Yes, okay, I understand it. But as a matter of fact, you have the agreement to lease the land on which the house is built, and it says that the house is a 12-floor house. In fact, you have 14 ones, and your apartment number 79 is not even in the documents. frankly, that's news for me. I know that there is a lease agreement there, but I didn't sign it. It was the developer who signed it. Well, were you careful enough when you signed those papers when you purchased the apartment? Well, if I was not careful enough, these were my risks, right? I did not impose any risks on any third parties. These were my risks, and if I am buying something, that I have those risks related to the use of it. Okay, in your explanations, you said that on the 14th floor you have some pipes there. Is that logical? But wouldn't that mean that that building is the technical floor? In other words, that can be commonly used by other residents. Well, in that case, they wouldn't have given me the registration papers. Those premises were separated at once. It was not an agreement, but rather the document saying that I participated in this cooperative house, and I was given the papers, the residential papers, saying that that was not a commonly used premises. Why I'm asking this question? Because you are saying that you are not opposing any risks in another person. No, in fact, you do, because in fact, if a building has been constructed to have 13 floors, that means you have an additional burden on the foundations. And if more floors are built, that means that the burden upon those construction elements is increased, and that creates a risk for all of the house. Well, if there were any violations, probably those buildings would not have been registered. Well, those floors have not been registered because as I look at well, frankly, I didn't go into, but even the lease agreement was provided to us only after we received all the package of documents, the purchase documents. Well, thank you. That was just my additional questions. A couple of questions more related rather to your answers that you gave to the High Council of Justice and their competition. It was a question about who had nominated you, information about the person who recommended you to take the position of a district election commission. Were you able to find out who that person was? Yes, I could. Can you give us the name? Yes, the following day after the interview with the High Council of Justice, I sent a request to the Central Election Commission. They sent it back to the Odessa archives several times, and that about a month and a half later, I received a response. This is the person you asked, or the members of the HCJ had asked me. That was the president at that time of the University of Odessa Legal Academy, Serhiy Kivalov. And as you were a professor of that university, as you worked at the university, but you could not remember who in fact had suggested you as a candidate for the district election commission, well, I assumed that by 90% or so it was that person, but I didn't have any documental proof of that, and I did not want to make a mistake. And I didn't want to make a mistake. That's why I sent that request. I received a response, and now I can. Right, thank you. We also have it. We have it in your files. Then I have my next question. Tell me, please, let's get back to the recommendation. One of the persons who gave you those recommendations was the lawyer of a certain law firm, right? In particular, he noted that for a certain period of time, and you in your biography also said that you worked at a law firm in 2008, 2009. Can you give us the name of that law firm? TOS S&S Legal Consulting. Right. And my next question is, can you explain why you do not feature the revenue received at the law firm in your tax declarations? Well, perhaps because that law firm, it's hard for me to give you the exact explanation, I'm just assuming. That legal firm was set up, there were two founders, co-founders there. One was a lawyer, another was a businessman from Odessa, who, among other things, had a share in a concern in Odessa. And as part of that concern, there were several enterprises. I don't know how many of them. And first, it was just a legal department that serviced the different companies. And there, the lawyers were registered as working for different companies. And perhaps that was the reason, and I could only see that recently. Maybe that's why they documented us as people working at those enterprises where we provided legal services. In particular, there was just one legal person that had a different kind of payment. That's Katan Group. So it turns out that you either worked for Katan Group or for a legal firm, but if you didn't receive any money from them, that means you didn't work there. Did you work as a volunteer? No, I worked there. Well, I cannot explain it to you exactly now why. Well, then just it's a question about whether your biography is correct. Well, I know that I worked there, and I have it registered in my labor book that I submitted to you. In other words, you worked there, but for free. No, I didn't work for free. I see. Then another question. That lawyer we're talking about, did he participate in the meetings of the High Anti-Corruption Court meetings where you were the assistant judge or where the judge was the president in those meetings? Well, I read the publication where that information was provided, saying that that lawyer had participated as a defense counsel, and in fact that publication features 6 case numbers. And last night I looked at all those case numbers to understand what the participation of that lawyer was. It turned out that in not a single of those cases, that lawyer had turned to the Court of Appeals with appeals, had not launched appeals, and perhaps in 4 cases he never even showed up, and he was not mentioned in the decisions as a process participant. In 2 cases, he participated in the trials, and he supported the positions of his colleagues, other counsels, orally, as he spoke during the trial. So in fact, I don't know where that information, well, I can tell you where this information did come. It's very easy to check it. You know, such a judicial service that is called the Status of Trials, that has a very good section which gives us the names of the parties. And when when a judge or a lawyer features there, then it would be, he or she would be named in this publicly available information. So it's not just a lawyer that was mentioned somewhere. It was a lawyer who was mentioned as a defense counsel in that judicial documents. I have, in fact, printed out all the conclusive parts of the decisions in each of those cases, And if you allow me to add that to the materials I've submitted, I would like to give that to you so you could have a look at where he participated. He could participate as a defense counsel at the first instance trial, but not participate as a defense counsel because it can happen quite often that the suspects or defendants would have up to 5 defense counsels and they would change them. They're either dissatisfied with them or cannot pay their fees. I don't know what their reasons can be, but they participate when lawyers participate at the first instance trial and others can participate in the appeals procedure. So in order for you not to have any doubts, if you allow me, I would ask for permission to give you a table which features all those case numbers, what that participation of that lawyer was, and what were the results of each trial or every hearing. Almost all the appeals were turned down. Well, I understand. The question is how other people treat that. This lawyer is a defense counsel, right? And this is public information. And he was a defense counsel in the cases where the judge whose assistant you were presided. In other words, that judge, he had all the files, all the materials, he would make the decision, and after that, that lawyer would give you a recommendation to be nominated as a judge of the High Anti-Corruption Court. Doesn't it look strange to you? If it looked strange to me, or if I felt any guilt here, I wouldn't have turned to him, and I have other persons to turn to. So this is the question, why you chose that person? Well, let me explain why I chose that person. When I learned that I needed to provide some recommendations, and perhaps to provide 3 recommendations, and I had the experience of working as an academician, as a researcher, as a practicing lawyer, and as an assistant judge. And I decided that from each of those areas, it would be good to receive a recommendation from the persons who knew me as a professional legal professional. And as during my work for a certain period of time, I worked at that time. I was a young lawyer, and he used to be kind of my teacher, and I think that I received some quite good practical experience from him as a lawyer, how to form positions when speaking at a trial. That was the reason. So you believe that you owe something to the person, right? Because he was your mentor. No, I don't think that I owe anything to him. It's just that I performed a certain work which he gave me as the superior. He knew how I did that, and he makes certain conclusions about whether I'm professional enough, whether I do not have enough experience or not enough competence for a position like that. All right, I understand. And finally, there will be one more group of questions, but to get back to our legal law firm, it looks a little bit strange that you didn't correct me when I asked you about the law firm. You didn't tell me that it was the same legal person with just 2 different codes. I'm sorry, maybe I must have missed it in your question. All right, never mind. And the last question that was also related to the questions that were asked by my colleague. Tell me, please, you said that you lived with quite a small amount of money, and in your calculations you take the minimum, let's say, salary or the subsistence level, the minimum subsistence level that you take to explain that your calculations were in line. No, I didn't say that I only had the subsistence minimum pay. I only provided it for comparison. And additionally, if you are asking me about my responses to the questions by PCIe, I said there that I had some other revenues that cannot be calculated. Can you tell me which revenues were there? These was the assistance I received from my parents. between 2004 and 2012. I looked it up. Your parents didn't have a lot of income to confirm that they could maintain you and help you while you lived in Odessa. I'm not saying that they had a big income, but they had their own savings. And my mother, for a certain period of time, was an entrepreneur. They worked all that time. I see. That's the end of my questions. Thank you. Dear Commission members, maybe you have any questions to the candidate? Members of the PCIe, maybe you have some additional questions to the candidate?
No, thank you, Chairman.
Дякую. Юрію Володимировичу, у вас є можливість, якщо є бажання.
Mr. Bodnaruk, if you want to, if you can turn to the Commission or to the Council, if you have any more additional information, but please be laconic. Well, as regards the questions that have been asked, if possible, I'd like to submit to you this information about participation of that lawyer who recommended me to the paper. So you would see that there was no positive results for the defense. If there are no objections, I'd like to ask you to have this information. Okay, I will ask the Secretariat to receive this information to share it with the Commission. Thank you. But as to, no, I don't have any additional documents or information. I want to thank you for careful attention to me, and I want to wish you all the success in this competition and the following ones. Thank you. Thank you very much. Thank you for your participation. Colleagues, we're going to have a 15-minute break now.